I am Dr. Gurujit Singh from Guru Singh Independence University, and today's topic of discussion is electronic contract, a very important part of cyber law. In fact, we need to talk about electronic contract because every other day we are entering into contract whenever we are being part of cyberspace or whenever we are opening an internet account or email account. Therefore, we need to understand the legal implications of various kind of activities we do in the form of contract in cyberspace. Prima facie, there are a few objectives of this module. The most important objective is to introduce various kinds of contract, then to talk about UNCITRAL model law of contract, and to compare it with Indian Contract Act and Information Technology Act 2000. Then to talk about the e-signature, which is very important part of electronic contract, and discuss some emerging issues or crucial issues of online contract, in particular the cross-border issues of electronic contract. To start with, we can say that in 1995 onward, internet becomes very important, and it was made available to the public for wider use. Seeing the potential effect of this internet in e-commerce, at United Nations level a committee was formed, and they drafted model law of e-commerce in 1996. Prima facie, there were three important objectives of model law of e-commerce. The first one was to facilitate commerce through electronic mode of communication. The second one was to provide some kind of uniformity to e-commerce. And the last one was to recognize the validity of e-commerce. With these three important objectives, this model law of e-commerce was created. Now it has three important prima facie principles which has been incorporated in fact every other state legislation whosoever has adopted this model law of e-commerce. The three important principles are non-discrimination on the ground that transactions are in electronic means. So the first one is non-discrimination. Second, technological neutrality, which requires that that the rule should be neutral for any future development. And the last one is functional equivalent, which lays down the criteria in which electronic communication will consider equivalent to paper-based communication. Based on this three important principles, the overall model law of e-commerce was created. In fact, you can see the reflection of all this principle in every other article of model law of e-commerce. To great extent, the same principle has been incorporated in Information Technology Act in India. Now, one thing has to be remember that model law of e-commerce is not a convention, but it's a model draft. So therefore, there is no ratification of this convention. So member states are free to adopt this model law of e-commerce according to their suitability. And so in India, we have adopted this model of e-commerce in Information Technology Act 2000. To start with, let's talk about different type of e-contract. More often there are four different kind of e-contract which we more often being part of, and they are widely known in the business circle. The first one is electronic data interchange, then click wrap contract, shrink wrap contract, and email contract. Let's start with electronic data interchange. Now this is the most, we can say this is the oldest form of contract in between a business to business form of transaction, whereby a standard business code or message has been created by the business house, whereby they recognize and give validity to different kind of agreement relating to different kind of transactions. So some of the examples are like purchase order, invoices, shipping notice, export import information, carriers to carrier, way bills, etc. Now this form of contract were very much applicable and used in fact before the introduction of internet or cyberspace. and so they are still relevant even though the internet is there and there are it has introduced various different kind of contract. Now the second mode of contact which is widely used in online contact is click wrap contract. We have witnessed to this kind of contract many of the time, and it is absolutely a different kind of contract if you compare it with the traditional mode of contract. In fact, this click wrap contract is derived from the shrink wrap agreements, which is there in when you go to the market and purchase CD, then you will find some kind of terms and conditions of license are mentioned in the CDs, and before operating or before opening the CD, you have to scrap that particular paper or the cover page of the CD, and once you do it, then it is presumed that you are agreed to all terms and conditions of the CD. So that is the shrink wrap contract. Now the same concept has been introduced in online contract, and it is known as click wrap contract. In this contract, what happens when you download a particular software or game on your computer, you will find some kind of terms and conditions, some kind of box as shown in the slides. This kind of box will come and they will say before being party to or before downloading it, you have to accept the terms and conditions of the software. If you accept, then only this software will be downloaded on your computer, otherwise not. I mean, there is no bargaining point. You can't do any kind of bargaining. You simply have to either accept, take it, or leave it. Therefore, this kind of contract are known as one-sided contract also. It doesn't give any kind of scope for the other person to do any kind of bargaining relating to any consideration or anything relating to the product. So they will only be downloaded to your software once you agree and you click on the I agree button of the software. Now, since it is different from traditional mode of contract, so at one point of time or at the initial point of time, we can say there was some kind of doubt relating to the validity of contract. But in fact, in various cases decided in US court, it has been held that this kind of contract are very much valid and legal, and there are some cases which I have already mentioned like Hotmail, CompuServe, Netscape. These are some of the contract of this type. Then the other contract is a browse wrap contract. Again, this is derived from shrink wrap contract, and to some extent they are similar to click wrap contract, except there is no requirement for express consent like in the case of click wrap contract, because in click wrap contract, till the time you don't express your consent, the contract is not complete. But in case of browse wrap contract, though the box may open up or the terms and conditions of download of the software or any other thing on your desktop may be conditional, but it is not subjected to giving the consent. So even if you don't give the consent and you access the software, many of the time the software will be downloaded on your computer. Now, one of the term or mostly the terms and conditions of this browse wrap contracts are like, by using this site, you agree to these terms of use. If you do not agree to these terms, you may not use this site. So it is presumed that once you are using this particular website or downloading according to the terms and conditions, so you are agreeing to the browse wrap contract. Even if you have not gone through personally to see each and every provision, howsoever reasonable, unreasonable they are, but because you are clicking and downloading it, so it may be presumed that you are very much part of the contract. Now, of course, at the beginning also, again, when this kind of contract started, there was some kind of confusion about the legal validity of this browse wrap contract. At the initial time, there was some kind of uncertainty relating to the validity of browse wrap contract. But US court has come out with various judgment where they have shown they are inconsistent on the validity of browser app contract, depending on how the terms and conditions of browser app contract has been reflected or has been shown on the website itself. Even in the case of browser app contract, since it is very much similar to click wrap contract, the other party doesn't have any kind of bargaining power, and whatever terms and conditions, even if they are reasonable, unreasonable, they have to be accepted by the other party. And relating to the validity of this kind of agreements and the contract, there are a number of cases which supports the validity of it. In fact, there are no cases even in the case of click wrap and browser app contract at this point of time in India. So we don't have any cases, but we accept that the grounds or the basis of which they have been accepted in US, most probably they will be accepted in India also. The last one contact is the type of contact is email contact. Now this is very much similar to the traditional type of contract which are being formed in Indian Contract Act, or which are being covered under Indian Contract Act. It is in the traditional form because here there are two different parties and they have plenty of time to decide about the terms and conditions, the terms of services, the kind of different conditions. They can always decide, they can bargain about the product, the quality of the thing they can ascertain, and many other things. So therefore to great extent it is very much similar to the Indian contract or the traditional contract being covered under the Indian Contract Act. The only difference is why they have been classified in Information Technology Act and electronic contract, because the contract is being generated through electronic means and they are happening online, and therefore they are being part of online contract. So here also there are two important parties in particular. The first one is addressee. It has been defined in IT Act also. So addressee is the person who receives the electronic record as intended by the addressee, and then the originator who sends, generate, store or transmit any electronic message or cause any electronic message to be sent, generated, stored or transmitted to any other person. So they are just like offerer and offeree, and the formation of contract is made in between them when the electronic message is communicated from originator to addressee, and then acceptance is being conveyed by addressee to the originator. Now the most important part is to be seen in this traditional online contract is that in this kind of contract they don't fall in the category of non-instances, they fall in the category of non-instantious services, for the simple reason once a offer has been or acceptance has been sent by the parties to the other party by electronic mode, then till the time that electronic communication is not being viewed, till that time the contract is not complete, and therefore they fall in the category of non-instantious services. Now from Indian perspective, one important case is there which has been decided in 2014, that is Trimax International FZE Limited Dubai versus Vedanta Aluminium Limited, where it has been held that this kind of contract are very much valid under the Indian Contract Act. Of course, Information Technology Act doesn't say, in fact the model law of e-commerce also doesn't focus or say anything that the whole contract has to be created on online contract, then only it can be classified as email contract. It may happen that a partial contract can happen in the traditional mode and partial contract may happen in the electronic mode, then also it can be covered under the electronic contract. Then coming to the legal validity of contract, which is an important aspect of Information Technology Act, which has been also covered by the model law of e-commerce. The purpose of model law of e-commerce was to give validity to any kind of e-contract, and therefore they had drafted in Article 5 the law relating to the legality of electronic information, and the article says that the information shall not be denied legal effect, validity or enforceability solely on the ground that it is in the form of a data message. So any information which is being generated through electronic mode, it has a legal validity. It can't be denied or it can't be discriminated that this is not created in the traditional mode, and so legal validity is not there. Now this is the whole basis of electronic contract, because electronic contract is nothing but transformation of electronic message from one party to the other party, and so on. Now further, Article 11 of Model Law of E-commerce talks about the legal validity of contract formed by electronic data messages. It says, in the context of contract formation, unless otherwise agreed by the parties, an offer and acceptance of an offer may be expressed by means of data message. Where a data message is used in the formation of a contract, that contract shall not be denied validity or enforceability on the sole ground that a data message was used for that particular purpose. Now that itself makes it ample clear that any kind of communication, offer and acceptance done by electronic mean of communication forms a valid contract. Now the same has been reproduced in to some extent in different languages having the same soul in section 4 and section 10A of Indian Information Technology Act 2000. Section 4 talks about the legality issue of communication, and it says, where any law provides that information or any other matter shall be in writing or in type written or printed form, then notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is rendered or made available in an electronic form and accessible so as to be usable for a subsequent reference. Further, section 10A, validate the contract formed by electronic mode of communication. It says, where in a contract of formation, the communication of proposal and the acceptance of proposal, the revocation of proposal and the acceptance, as the case may be, are expressed in electronic form or by means of an electronic record, such contract shall not be deemed to be unenforceable solely on the ground that such electronic form or means was used for that particular purpose. So that amply clears that we incorporate, in fact, whatever model law of e-commerce has to say on the issue of validity of e-contract. But the Information Technology Act makes an exception that in these 5 cases, even if the electronic mode of communication happen, then only they can't form the e-contract. They can't, and this e-contract will not be valid as per the law. Therefore, those category of contract can be negotiable instrument, power of attorney, trust, will, sale of conveyance of immovable property. So these 5 different category of contract, even if made through electronic mode, even if according to information technology, then also because they are not recognized by the act itself, that therefore they will not be a valid contract, and for them you have to follow the route of traditional mode of contract. Now the further issue is relating to attribution of the contract. Many of the time what happen, since now technology is providing artificial intelligence also, therefore many of the time it happens that you have programmed your computer in a way that in absence of your, the computer can take decision on behalf of you. So it may happen that a computer may report to the vendor if they found that the inventory is empty or there is a shortage of product. In that case, who will be liable for any kind of breach of contract, whether there is a valid contract or not. Now in this case, to cover up this kind of situation, Article 13 of Model Law of E-commerce has a sufficient provision regarding it, which has been incorporated by Section 11 of the Act also. And it says, an electronic record shall be attributed to the originator if it was sent by the originator himself or by a person who had the authority to act on behalf of the originator in respect of that electronic record, or by any information system programmed by or on behalf of the originator to operate automatically. So even if your computer operates in absence of you, because you have programmed the computer in that way that computer can take decision on your behalf according to the program, then the contract will be attributed to you and you can't deny your liability in that regard. Then the most important aspect of electronic contract is e-signature, because signature gives you authenticity relating to the contract. Now in traditional mode of contract, signature plays an important role because it gives authenticity. At the same time, it expresses that the other party has given the consent relating to the contract. Now how that has to be confirmed in information technology, that was a challenging task. Now Article 7 of Model Law of E-commerce defined the concept of electronic signature. To a great extent, that has been incorporated in Information Technology Act in India, and at this point of time we have digital signature as well as electronic signature as a mode of authenticating the online contract. Though this kind of signature may not be required, particularly in case of click wrap contract or browse wrap contract, but they may be very valid or they may play an important role while you are conducting or while you are doing a contract through email contract. Now Section 3 of Information Technology Act allow the authentication of electronic records by affixing this digital signature. Now it is important to understand how this digital signature function. For digital signature, there are two important keys which plays an important role. The first one is public key and the second one is private key. Any individual who wants to have a digital signature has to take the permission from digital authority, certifying authority of India, and then there is a requirement of hash function. Now when sender sends a information to the other party, or originator sends the information to the other party in the form of contract or offer, then first of all he has to write a message. After writing the message, he has to apply the hash function, and once hash function is applied, hash function in a way envelop the whole message and provide security to the message. Then the message, that private key of the originator will be applied on that message, and then the message will be sent to the addressee. Once addressee gets the message, then he will apply the hash function just to ascertain the authenticity of the message which he has received, just to ascertain whether this message has not been modified or altered after being discharged by the originator. Once he confirms it, then he will apply the public key, which is available on the website of agencies, and taking that public key and applying that public key, the message can be recovered, and it can be ascertained that this message is very much from the originator. So that way the authentication happens by the use of a digital signature. Section 3 of IT Act, Information Technology Act, now also talks about electronic signature, and it allows authentication of electronic records by the use of e-signature if it is reliable. And it provides the reliability test in the section itself. Now, these were some of the fundamental issues relating to e-contract, like types of contract, and some of the important issue like validity of the contract, attribution of contract, and e-signature. Now come to some legal issues of electronic contract, because they are different from the traditional mode of contract, and therefore they raise some important issue which has to be addressed properly. In fact, if you see from the Information Technology Act and Indian Contract Act, you may not find the answer, but we need to search the answer in some way. So there are some important issues which I want to discuss. The first one is the issue of jurisdiction, consumer protection, choice of law, capacity of party, and lawful object. Starting with the jurisdiction. Now, we understand that one of the most powerful tool or powerful concept or benefit, one of the most important benefit of contract is that it gives the autonomy to the both parties. Unlike the traditional mode of contract, electronic mode of contract gives the party ample power to form contract from any jurisdiction, any state. In fact, many of the time cross-border contract are also formed. And this is only applicable, or this is only allowed because the information are accessed across the border also. Now, if that is the scenario, then how the jurisdiction in case of any conflict between the party will be decided by the court. That's an important issue, because it may happen that both parties are living in two different states or operating from two different states, and the contract might be happening in third state. So it is important to understand whether the court has a proper jurisdiction to decide that kind of cases or not. Now, to understand it, I can categorize the situation in two ways. The first one is, let's take a national perspective issue, and the second international perspective. If the issue is a national, saying thereby if the parties, both parties are within the nation itself, within India itself, then deciding the contract will be according to CPC, which allows which in section 20C of CPC gives the jurisdiction ground. At the same time, party can decide their jurisdiction, so there will be no conflict and they can decide their jurisdiction. The problem is with regard to cross-border contract and their jurisdiction. Now, in this regard, if the party, first one, the jurisdiction will be decided according to CPC. Second, the party has also the autonomy to decide the jurisdiction beforehand entering into the contract. If that is the case, then two important requirements has to be made according to Hakam Singh versus Gammo India Limited case. The first condition is that the court selected should have the inherent jurisdiction, and second, the choice of forum agreement can only exercised where more than one court has jurisdiction. Common consent of the parties are required in this regard. That is perfectly all right, but this kind of jurisdiction creates obviously problem in case of click wrap contract and browse wrap contract, where the parties may not be within the nation and they may be in the cross border, and they don't have any choice of bargaining, so they may not be able to decide the terms and condition. Jurisdiction may be important part, but because it's a click wrap and browse wrap contract, many of the times, in fact every other time, it has been seen that they decide the jurisdiction even if it is unreasonable to the consumer. Let's talk about email contract. When you open an email account, you have to fulfill some terms and condition of email account, and one of the terms and condition of email account is that it talks about the jurisdiction of the parties. and the jurisdiction is most of the time is in USA, California, New York, etc. These jurisdiction grounds are absolutely unreasonable for Indian party, but they don't have any choice and they have to accept it as it is. So that is a legal issue of jurisdiction that creates a problem for the parties because there is no common consent on that particular clause. The next point is choice of law, which is again an important point of contract, online contract. In the contract, again, it gives autonomy to the both parties to decide the law which will be applicable to resolve their disputes in the future. Many of the time the party decide the choice of law beforehand, and many of the time in the absence of decision relating to choice of law, depending on the fact and circumstances of the case, choice of law is decided. Now in the online contract, in particular the cross border online contract, in the absence of any kind of decision relating to choice of law, we have to depend on many factors to decide the law which has to be applicable. Now in case of National Thermal Power Corporation versus Singer Company, there are some 7 factors which has been recognized, which may be important or which may be hinting to one particular choice of law which may be applicable. Now which factor has to be given more importance depends on the fact and circumstances, but the court recognized 7 different important factors. The first one is the place of formation of contract, second the place of performance of contract, second third place of domicile, fourth place of residence, fifth place of business of the parties, sixth national character of the corporation, and the seventh subject matter of contract. So there is no uniformity at this point of time from Indian perspective as to which factor will be important or which factor will be the final decision making. Depending on the fact and circumstances, that has to be seen. Then the next important point is capacity of contract. Now to become a to create a valid contract, one of the most important requirement is that the party should have the capacity to contract, and according to Indian Contract Act, section 11 lays down the capacity of contract when it says every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. So saying thereby majority is the rule. If the person is mature, saying thereby if the person is of 18 years plus, then he can form a contract, a valid contract. But in electronic form of contract, particularly click wrap and browse wrap contract, there is no scope to verify the age of the other party. So many of the time it happens that the teenager download the software and they form the contract in some way. Even if when you are opening the email account, many of the time the party gives the false information about their age and majority and they form the contract. Now this kind of contract is not valid according to section 11 of the contract if the party is not mature enough. Now how to verify the age of the party is an important task. Then the next important issue is lawful object. Now lawful object is again very important. Any object, every contract has some kind of object. Many of the time they are lawful object, many of the time they are unlawful object. So any unlawful object, if the contract has, then that kind of contract is not valid. But since the transactions are happening, if the transactions are happening cross border, then how to verify whether, first of all, what is the object of the contract, and even if you can verify the object of the contract, whether that object is lawful or unlawful, sometimes it creates problem, because it may happen that a object may be lawful in one state and it may be unlawful in the other state. For example, in case of gambling, India doesn't allow or prohibit gambling, but some other countries allow gambling and any contract which has a gambling aspect, they promote it, so it's valid. But if a cross-border transaction happens or online contract happen between an Indian party and other state where gambling is allowed, then the purpose is very much known that it is unlawful object. But what about the validity of contract? It may be a valid contract in the other state where gambling is allowed, and it may be a invalid or void contract in Indian perspective. So that has to be seen after understanding the laws of the other country on the same point. So that creates some problem. So wherever e-contract has a cross-border aspect, that may create some kind of problem about the legal or validity of the contract. Otherwise, if the issue is within the nation itself, within the territory or within the jurisdiction of India only, to a great extent the answers lies in Indian Contract Act as well as the Information Technology Act. With this, I conclude my module. Thank you.